Well, thank you all for the contributions that you're going to make. And Monique is going to be our speaker, and Matthew's going to be the moderator. We will entertain questions at the end, so put them in the Q&A box, and we will ask them to our panelists, and this will be the format we will be using throughout the day. So again, thank you so much for being the first to start our lovely day.
Great. Thank you, Yvonne. I'm honored to introduce my fellow colleague, Monique Mehmi, a first-year PhD student at the University of Liverpool. Monique has a keen interest in how unaccompanied asylum-seeking children's rights are impacted by age assessments. Monique and I Zoomed the other day so I could learn more about her as an academic and as a human. I could go on about her research into making our world a more just and accepting for all children, or about her accomplishments to date. But what I found most intriguing is Monique's willingness to step out of her comfort zone, to take a seat at the table. And I was taken by her passion for research, for her desire to effect great change, and for her concern for me and the other fellows. Monique will be presenting her research, Age Assessments, Blurring the Lines of Childhood and Adulthood. Remind me, Monique, mushy peas or not?
No mushy peas.
Good luck. Enjoy your presentation.
Thank you so much, Matthew. Thank you, Yvonne, for giving us, all us fellows this opportunity. I'm just going to share my screen now. This title on the screen, I said to Matthew the other day, this is actually my thesis title, and this is what I want you all to have kind of in mind when you're listening to this, is that I want to kind of blur those blur those lines of childhood and adulthood, although this presentation will be on the legal challenges of age assessments, but I want to look at kind of that age of 18, and I want you all to keep that in mind, that is my kind of end goal here for my thesis. So I get asked all the time, what are age assessments? And essentially an age assessment is conducted when an unaccompanied child arrives at a border and they have no documentation. It is then border agencies or social workers who conduct this assessment to find the chronological age of an unaccompanied child. And that chronological age is kind of their aim. And I don't know what my slides are thinking the other way. Apologies. This chronological age is kind of their aim, but it is very impossible to find a chronological aim. So why do they conduct these assessments? They conduct the age assessment to put that child into the correct form of care. So education, accommodation, welfare. Obviously, we all know that children have a different set of protection rights. And if an unaccompanied child is entitled to that, they should be put in those special education, accommodation, etc. However, it's all dependent on if they're found to be children. So this is where the issues kind of come up, and we can see this from practice in everyday life. There's these resource issues. There's this issue that, we can't put everyone into education, into accommodation, into care, etc. And it's almost this strategic kind of resource issue where, we can't give this to everyone, but there is the opportunity to kind of raise these issues here. And something we'll talk about in a second, which I'll get into later, is something called aging out, or what we refer to aging out. And this is where authorities will delay an application due to these resource issues. And they will basically say, oh, well, you might be 16, or we might think you're 16, but we're going to delay your application for 18 months, 2 years, and wait till you age out and become 18, and you're no longer our problem, essentially. And this is where the issues start to come up. So how are age assessments conducted? They're conducted through an assessment, so normally through an interview. They could be done like physical assessment, medical assessments. But I put there on the slides, they're normally done through something called a holistic method. So holistic meaning, taking into account the child's sociological, psychological, physical appearance, looking at their journey, making sure that, we understand what, kind of them as a person before making that age assessment. And like I've mentioned there could be physical or medical. And just to give you examples of what a medical age assessment could look like, they're kind of done through X-rays, so of the wrist, the jaw, of the teeth. They do sexual assessments, so puberty assessments. But the problem with these medical assessments is that they can be plus or minus 2 years to the assessed age. So this meaning that if you are, age assessed as 16, you could be as young as 14, or you could be as old as 18. So you can see the discrepancy in those age ranges as is. So it's, you can see here that, they're not very reliable. And there's just no way of guessing someone's age just by looking at them, just by saying, oh, I've done an X-ray. This could be your age, but this could also be your age. It's not a reliable way to assess people's age. So going into the legal challenges here. So I've just set out there the international framework that I am working from in my thesis. So I've got the very core principles, Articles 2, 3, 6, and 12 of the UNCRC. I also use Article 19 there, so protection from violence. Then we've got the Article 3 and 8, ECHR rights. So this is the European Convention of Human Rights. The UK is still part of the Council of Europe, so the convention still applies to us. So this Article 3 is to do with prohibition of torture, and Article 8 is to do with the right to respect for private and family life. I've also put there the Article 31 of the Refugee Convention, which is it basically says that states should not impose penalties on those who illegally enter countries. So massive issue here that we are seeing. Not well, I'll get into that later about the domestic framework, but you can see there that we have the Refugee Convention there that says that we shouldn't be imposing penalties. And general comment number 6, now this comes from the Committee on the Rights of the Child, and this is a general comment that basically highlights the vulnerability of unaccompanied children, separated children, who face challenges. So going into the main two principles, so firstly we have, so this is from the international guidance. The international guidance basically has this, very blanket principle that when we are dealing with age assessments, we don't know the age of someone, we should give them the benefit of the doubt that they are a minor. They sometimes refer to it as a presumption of minor, so I've put that there just in case that comes up a bit later, because they are kind of used interchangeably. And we've got a couple of definitions here. So the Council of Europe says that due to there not being that definitive way to measure a child's age accurately, the benefit of the doubt principle must apply until there is conclusive evidence that they're not a child. So very clear definition here of give them the benefit of the doubt that they might be a child. If there's some assessments or documentation, anything else kind of arises to say that they're not a child, then obviously we treat them in that as an adult from there. General comment number 6, I think, has some really good points that the age assessment should be safe, it should be child and gender sensitive, and the individual should be given the benefit of the doubt. Very simple, but it needs to be said. It needs to be said that age assessments shouldn't be invasive, they shouldn't be harmful, they shouldn't, re-traumatize these people, obviously, because they've gone through journeys that we don't, have no idea about. And I think that's really important issue. The UNHCR actually has a really good kind of view of age here. So they've kind of described that age is not calculated in the same way universally or given the same degree of importance. And I think that is so important. And that has actually guided the rest of my thesis, and to kind of look at age as a concept and why we consider age differently in the West and why it's different, in other parts of the world. And I think that's a really important issue. And finally, the EASO, I have to kind of go back to the Council of Europe, they've got very similar definition there, that the applicant should be considered and treated as a child until he or she is found to be an adult. And due to the inaccuracy of the potential intrusiveness of the current methodologies of age assessment, which I just mentioned, the systematic application of benefit of doubt should be applied throughout the whole age assessment process. The second principle relates to medical age assessments. So essentially, the measure of last resort is something that the international policy seems to agree on. So it's a very established principle. So the measure of last resort kind of relates back to those medical age assessments that should be used as a measure of last resort when there is all other avenues have kind of been exhausted. As a measure of last resort, we're going to medically age assess this child. We don't see that. We see, a lot of member states go straight in for the medical assessment. They don't exhaust any other avenues. They just say, well, it's a quick way to kind of, put an age on someone. And I think this the literature here that I've put, so this is Greg and Knoll in 2016. He identifies that medical and radiological age assessments are problematic and that it can raise a number of issues relating to those human rights. And I think that he also he emphasizes that the nature of the age assessment, the medical age assessment, stems from, I don't know why my slides are flicking, sorry, apologies. He emphasizes that the nature of the age assessment stems from the doubting of the age. So if you're doubting it to already begin with, then that doubt is still going to linger throughout the whole age assessment. And I think that's a really interesting concept. Even if there is this, medical age assessment. So going through some themes from the international guidance, I've put here on the slides some very general themes from the international guidance. You can see there that the non-discrimination of the child, the respect for the abuse of the child, best interest of the child are very core themes from the UNCRC. But they have this other theme that they talk about, the margin of error. Now, this margin of error relates back to not only medical age assessment, there is margin of error that I mentioned before, the plus or 2 minus years. But margin of error of just looking at someone and saying, you could be this age, you could be that age. And there is that margin of error in doing that physical assessment as well. So going into more of a specific, so when I kind of unpick this a little bit more, I got these 3 main themes, which I'll be using throughout my thesis. And starting with no delay. So this is what I mentioned before, that member states will, or authorities will basically delay applications to not have to use resources essentially. And the international policy on delay establishes that delay shouldn't be condoned, so it should be avoided at any point. You shouldn't be delaying applications. You should be putting applications through as and when they come in, and it also says that if delay does happen, it will leave the child without support and fails at providing that child-centered approach. Going on to the non-invasive, so the guidance here reiterates that the age assessment should be conducted through the least invasive examination to respect the individual's dignity. And this is an important aspect of the policy because this aligns with the Article 39 CRC, right, that children are entitled to recovery from trauma and member states should support them to recover their dignity and self-respect. It should also consider that if an age assessment is in the best interest for the child. So in 2022, the Council of Europe had argued that, you know, age assessments, whether physical or medical, should only be conducted if it's in the best interest of that child to be undertaken in the first place. And this kind of shows that maybe that best interest assessment actually needs to be done before we even apply the benefit of the doubt. We need to be thinking about, you know, what is in that best interest for that child. And lastly, the cultural sensitivity. So excuse me, cultural sensitivity concerns anything, but is not exhaustive to, you know, your nationality, your social origin, your ethnic background, gender, language, religion, disability, sexual orientation. And age assessors should be thinking about these issues. They should be thinking about these things that I've just mentioned. And this kind of cultural sensitivity stems from what age assessors deem normal. And I think it can be said here that this is not a normal situation. So normal is not that starting point. And it's evident that a lot of cultures and backgrounds are so different all over the world. And it's the responsibility of the member states, and more importantly, like I said, the age assessors, to bypass this bias and make judgments of the ages of unaccompanied children on an unprejudiced level. So remember at the start, I mentioned these holistic age assessments. So like I mentioned, they kind of take into everything into account, you know, psychological, medical, sociological, physical. But upon doing some reading, I actually came across something from Denver 2018, which really made me rethink this holistic age assessment. And Denver believes that the holistic age assessment can be a bit hit and miss, because if used on their own, so all these, you know, elements, physical, medical, psychological, sociological, if used on their own, they actually don't provide solid evidence on their own, used in isolation. So she kind of highlights how it's kind of illogical for holistic age assessments to contain individual elements that don't actually work on their own. And it should consist really of minor but still functional elements that once brought together are a powerful framework that anyone can work from. So like I've got on the slide, so just to kind of give you a floor of each kind of element, you know, in the physical age assessments, you know, we're drawing conclusions around demeanor. It could be seen as kind of that guessing game, and it doesn't allow for that accurate assessment. And that's essentially what they're trying to look for. They're trying to look for this chronological age, aren't they? And it doesn't allow for an accurate assessment. Excuse me, just and the medical age assessments can be proved to be invasive and undignified for unaccompanied minors. You know, imagine going around and measuring limbs or taking x-rays. These things are traumatic for unaccompanied people, so we shouldn't be subjecting them to these kind of assessments. Psychological, again, it could be proved to be traumatizing or re-traumatizing to talk about their journeys for the unaccompanied child. And finally, sociological. So this is what I talked about before with that cultural. So talking about development and looking at the journey of the unaccompanied minor, and this shouldn't be skewed by the Western biases that we have. You know, and you can see here all these kind of elements are all flawed in their own regard. And why are we kind of lumping them back together and saying, oh, we'll call it a holistic framework? It just doesn't sit right with me. It doesn't work. And I think this could be problematic, and it needs to be more child-centered. So going into the European Courts of Human Rights, I've got a case here that I'm just going to quickly go through. So this is Darbo and Kamara. I'm just going to refer to this case as Darbo, just so you're not getting confused. So Darbo arrived in Italy as a 17-year-old, where his age was not contested in the first instance. A month later, he was then subjected to medical examination to determine his age through the X-ray of his wrist. And this test had basically corresponded that he was an 18-year-old male. He alleged that his consent to undergo the medical examination had not been acquired, as well as not being given a copy of the assessment, or that there could be a margin of error. So procedurally, his case was flawed from the very beginning. He was also not given a legal guardian, even though he declared that he was an unaccompanied minor. And as part of his complaint, you can see there was, complaints about his living condition, lack of water, knives and narcotics in circulation, lack of healthcare. And essentially, he'd lodged a request to the courts to be transferred to facilities where his reception conditions as an unaccompanied minor could be ensured. He felt that living in an adult facility was a risk to his life. And this is the basis of his complaint. So, the moment that Darbo had been forced to undergo that age assessment procedure was the moment that his Article 8 rights were breached. So, just to remind you, that's the right to respect for private and family life. And the European courts found that the Italian authorities failed to apply the principle of presumption of minority, which is that benefit of the doubt principle. So they failed to apply the benefit of the doubt principle and reiterated that this was an inherent element of his protection under the Article 8 right. Like I mentioned before, because he was given no legal guardian, there was no standing in the proceedings before the courts. And the best interests of Darbo in this case lies in the fact that he should have been appointed that legal guardian as he was an unaccompanied minor. And he shouldn't have been subjected to a medical assessment, even though they did not contest his age in the first place. It's very evident here that Darbo's best interests were not considered during the process, and the courts did find that there was a breach of his Article 3 rights, which was prohibition of torture. So it can be seen here that the Italian authorities didn't find that presumption of childhood, and that's where his rights were breached. So, going more into this Article 8, right to respect of private and family life, the court's kind of examined here the violation of Darbo's Article 8 rights. His complaints, obviously, as we mentioned before, were based on the fact that he was not found to be, that the authorities failed to recognise his rights as an unaccompanied asylum-seeking child, and that the violation against his right to respect for his private and family life was due to the lack of that protection that they didn't provide. And they highlighted that the lack of access to legal information has led to quite a difficulty in communication regarding his discomfort and needs. So, i.e., that means that he had no interpreter, he wasn't able to communicate. And I think, yes, we can talk about how procedurally flawed this is, which exactly is exactly what it is procedurally flawed. But we'll go on to a second. We could talk about that in the next second. The court kind of scrutinised the issue of subjecting the minor Darbo to a medical age assessment as a violation and a invasive method to judge age, and they draw on the fact that there should be this multidisciplinary approach, there should be holistic, and the approach could, that they use is basically inflicting harm on Darbo rather than benefiting him. So they did a third-party intervention where the third party had stated that the medical methods should be avoided due to its low evidential value. That it should be due to their low evidential value, the intrusiveness of a risk of a disproportionate interference with the child's private life that may lead to that violation of Article 8. And when you read the case, it becomes quite apparent that the courts actually ignore this and still focus on that lack of procedural safeguards that we talked about. So, lack of information, not having an interpreter, the way that he was, kind of failed in that regard. So the courts talk about this child sensitive age assessment, and they talk about it should be child sensitive and holistic, but they still comply with the medical age assessments. And like we mentioned before, that medical age assessment should only be used in the as a measure of last resort, and they didn't do that. They actually accepted that he was a child first, and then went back on that and thought, oh, we'll just do the medical age assessment. And this is kind of a missed opportunity from the court to say, actually, we need to set a minimum or create a minimum standard on the use of medical age assessments. But they didn't do that, and it's a bit sad to see that they didn't explore that issue of medical age assessments a little bit more under that principle of a measure of last resort. So overall here, the Italian authorities failed to apply the principle of presumption of minor age to Darbo, and they breached his article rights, as we can see, and as we have discussed. But again, there is this issue that they've relied so much on procedural irregularities, and they're kind of squandering this opportunity to establish a new principle around invasive age assessments. And they focus on, the lack of a legal guardian and right to information. But like I mentioned, it should have been an opportunity to talk about the invasiveness of medical age assessments. So the Committee on the Rights of the Child actually has a communications procedure, which is essentially where we can come forward and complain about your procedures. So I'm just quickly going to run through this one. This is a complaint of JAB and Spain, and the committee acknowledged here that the complainant looked like an adult, and quickly recalled general comment number 6, which confirms that an age assessment must not take into account only the physical appearance of the individual, and in the event of an uncertainty, the individual should be accorded the benefit of the doubt, such that there is a possibility that the individual is a child, he or she should be treated as such. So again, we've got the committee saying, or really hammering down that the benefit of the doubt should be applied here, and it's not a principle that's getting used a lot. So we need to be pushing for this benefit of the doubt. And the principle should guarantee support and protection for individuals involved in the procedures, and the committee has demonstrated here kind of how they have interpreted that principle of presumption of minority of a minor to include a duty of transferring the child to child facilities, and they've kind of quite strongly rejected arguments from member states that they would result in risk to other children. So member states are essentially saying, oh, we don't know if this person is a child or not, they might be an adult, but if we put them in a child facility, they could be a risk to that child. But that's not what we're seeing in practice. We're seeing a lot of people being misaged, age assessed wrongly, and it essentially sometimes gets to court, and an age assessment actually shows that they're a child. So this is a very quite a big part of my first couple of chapters actually, is a children's rights-based approach to age assessment. And I quickly just want to give you an overview of that, that the children's rights-based approach is an already established it's a very established approach. It's actually adopted from a human rights-based approach, which is kind of based on principles of participation, accountability, non-discrimination, equality, and power, legality. However, the children's rights-based approach actually contributes two more things. The right to life, survival and development, and that best interest. Again, core principles from the CRC. Just to give you a kind of overview here, how important a children's rights-based approach is. Kilkelly and Lundy in 2006 say that the rights of the children and young people, setting out how they're both to be promoted and protected, is unrivaled in terms of their comprehensive nature, international and national standing and relevance. Jane Fortin says in 2009, the touchstone for children's rights throughout the world, that a children's rights-based approach is a touchstone for children's rights-based to children's rights throughout the world. And I think that's a really great way of putting it. And you can see there I've put some other references kind of talking about so James and Prout kind of talk about this autonomy and bringing that child to the centre, and that's what we should be doing in a children's rights-based approach. And I think that's really important here in an age assessment. So now I'm quickly going to go on to how the children's rights-based approach kind of relates to age assessment. So again, starting off with our core principles here from the CRC, and that's kind of what I based it on. So looking at the best interests of the child, very simple, the child should be respected at all stages of an age assessment procedure, and it should only be conducted, the assessment should only be conducted if it's in the best interests of that child. Article 12, respect of the views of the child. So this is essentially, we should just be more than respecting the views of the child here. And this idea comes from Stalford, and she kind of highlights that under Article 12, it's very hard for unaccompanied children to kind of express themselves freely, and it's kind of very heavily determined on the adversarial nature of asylum proceedings. So to be taking on board Article 12, we need to be just more than respectful. We need to be making an environment where they are able to open up. And, interviews, like I mentioned before, they're probably not the best place for them to open up. And I think this is what we need to kind of look at a little bit more in detail. Article 2, so the non-discrimination, we shouldn't be using age assessments to discriminate against a child. We shouldn't be taking, their ethnic background, or, like I mentioned before, they need to be culturally sensitive. We have seen in the UK a lot of unaccompanied children from Albania and parts of the Middle East be discriminated against just because of their nationality or where they're from, their ethnic background. And I think this is a severe breach of their non-discrimination rights. And finally, the right to survival, life survival and development. So children should be able to grow up in conditions that don't impact negatively on their physical and mental well-being. And I think this, coupled with Article 19 of the CRC, which is a protection of from violence, abuse and neglect, kind of shows that we should uphold that dignity of that child, to kind of uphold those procedural safeguards. And these articles should all be underpinned by General Comment number 6, which I mentioned before, which kind of illustrates that age assessments, the article number 6 kind of says that age assessments should be conducted holistically and, with acknowledgement to their human rights. And this is what we should kind of be looking at. But we also need to be kind of pushing for this benefit of the doubt. This is a very established principle in the international guidance, and there's not enough push or enough use of it. So kind of to conclude, the international framework, it focuses more on improving the accuracy of an age assessment to find that chronological age, rather than improving on the implementation of the benefit of the doubt principle and the measure of last resort principle, which we mentioned. From my own conclusions, I do think that the holistic age assessments are problematic. I don't think taking small elements that are flawed and putting them all together to say, oh, it's holistic. It's not a very good framework if each of those individual elements are flawed. And that when we're looking at a children's right-based approach to age assessments, we need to be making it more child-centered, putting that child at the center, like I mentioned. And that Article 12 is really important here. So quickly going on to the domestic and UK framework. So here I've put kind of the framework that I will be using in my thesis, but I'm only going to focus on the top two there. So Section 55 of the Border Citizenship Immigration Act. Essentially, this is a section that requires the Home Office to carry out its existing functions in a way that takes into account that they need to safeguard and promote the welfare of the children in the UK. So essentially, this was a section that came in to extend duties of needing to safeguard and promote welfare to children in the UK to Border Force. So this is specifically to do with Border Force. And this, you can see that this is a duty that is informed by the CRC best interest principle there, and it does aim to address kind of vital aspects of unaccompanied children's lives by having that regard to safeguard and promote welfare in the UK. But again, this is a section that doesn't get used very well when put into practice, and there needs to be this push for using Section 55 here to safeguard and promote the welfare of children in the UK. And the second one is Part 4 of the Nationalities and Borders Act, which is sections 49 to 57. So there's a lot of sections there. But it intends to bring age assessments into the statutory system, which was previously developed through case law, which I'll talk about in a second. But the Nationalities and Borders Act actually provides very little support for the young person undergoing the age assessment. It creates this two-tier refugee status that proves to be quite difficult to bypass, and it generates harm, and it develops some seriously hideous narratives about young people seeking asylum. So going into the UK case law now, this Merton was the first case about age assessments, and it was a very procedurally flawed case. So I'm just going to quickly take you through the facts of this. So this case concerned a boy. He arrived in the UK. He came from Senegal in 2003, and he was taken to the Refugee Council where he was accommodated for a weekend. He was then interviewed by a social worker where he was handed a letter from the Home Office stating that they did not consider him to be a minor and they refused support. And this is where the interview kind of turned really problematic for a number of reasons. The social worker didn't speak the claimant's native language of French. So they had to use a phone interpreter, and the phone call was conducted via a loudspeaker, was not conducted by loudspeaker either. So essentially, the phone was passed from social worker to the interpreter, to the claimant, back to the interpreter, and back to the social worker. So showing that there's this lack of transparency between the three people. The social worker also did not keep a verbatim record of the interview and just completed a form after. And some specifics that the social worker had actually noted in the form was the claimant's ethnicity and faith, which again, going back to those non-discrimination of Article 2, we shouldn't be doing this. It's not something we should be discriminating against. So the social worker thought that he was that of a much older man, and that he was in his late teens. But it was quite interesting because on the form, when it got to court, the social worker had written the age of 16, and then wrote over it with 17. And this was kind of dismissed by the courts to say that it was, potentially an incorrect working out of the claimant's age. And the social worker's defence was that she thought that the claimant was not a child in need and did not dispute that he wasn't in need of his own right, but she was just taking the stance of the Home Office. She also stated that he was youthful in appearance, but still argued that he was 18 to 20. She felt that he was mature and confident, and the confidence was unusual for an unaccompanied minor. And again, you can see where these discrimination, some of the principles we've talked about before, how this is exactly what's happening. So the issue at this point was obviously that the age assessment was procedurally flawed. And the court said that they needed to actually reconsider the age assessment here. And ultimately, like you can see on the screen, this is the case that established the what we call now the Merton compliant age assessment requirement, which is used when there is reason to doubt an individual's claimed age, so they're treated age appropriately and receive those necessary support and services. Just to kind of go over a few parts of this assessment, I won't go over all of it, but age assessments cannot be made solely on the appearance, should be holistic, should be taken into appearance, background, etc., what we've talked about before. That the age assessment should look at the medical history, the family history, the social history. There's a duty for the decision makers to give the reasons for the decision. And the young person should actually be given the opportunity to answer back to those decisions. And I think that's where that Article 12 right really kicks in. Very importantly, it must be conducted by an experienced trained social worker. At the moment in the UK, we're kind of having some kind of problem with who is conducting the age assessment. So that's going to be part of my thesis as well. But the most important part of the Merton compliant age assessment is that if the decision maker is left in doubt, the claimant should receive the benefit of the doubt. And that is hammering home that kind of point on the benefit of the doubt principle. Okay, so I'm just quickly going to rush through this. So the UK actually departs from the international guidance, as we can see. It really departs from those principles, those core principles that we've mentioned. Couple of cases here, so I just want to quickly go through these. The case of BF Eritrea was a Supreme Court case where BF had entered the UK, claimed he was an unaccompanied child, that he was 16, but it wasn't until the third Merton compliant age assessment that they considered him a child at the time of arrival. And there was a lot of procedural policy guidance that was discussed in the court, but essentially BF raised a judicial review to quash kind of the guidance of kind of unlawfulness of guidance around physical appearance and demeanor. The guidance kind of said that that if their physical appearance or demeanor very strongly suggests they are significantly over 18, and there's no other credible evidence that existed to prove the contrary, you can basically say that they're over 18. And again, it's this physical age assessment. The problem with BF Eritrea is that the Supreme Court kind of concluded that the Home Secretary's policy approaches to the way that the immigration officers should distinguish adults and children as best as they can using the best available evidence was lawful. They said that they were allowed to do this, and they argued that it had contained all the safeguards that are needed, and this was a huge issue. Because we saw there was a lot of problems here to do with procedure and making sure that that there was this met and compliant age assessment. There was a lot of problems in this case, and that this case really kicked up a fuss for everyone kind of in age assessments, that essentially there was going to be this problem. We were going to see a lot more adults, children who were told they're adults, and that was a massive problem. In the case of and London Borough of Croydon, the courts held that it wasn't lawful for London Borough of Croydon to do this age assessment. So we've got here two kind of different, obviously, this case was before BF Eritrea, but we can see at times the courts are understanding, you know, they're understanding of this statutory guidance, and the courts are good to pick it out at times. I think this is the issue that I'm trying, the kind of, you know, argument I'm trying to make, is that we shouldn't be departing from that statutory guidance, and the courts picked that out. They said that there wasn't a good enough reason to depart from that statutory guidance, and they should have applied the benefit of the doubt principle in this case, because they have an obligation to provide support to an unaccompanied child pending their age assessment. So I'm not going to go over all these examples just for the because run out of time. But I just wanted to overall conclude here that the international guidance gives those core principles and themes that should underpin age assessments. And international law kind of shows that there's this focus on procedures of age assessments, but the committees on the rights of the child's communication procedures shows that they want to support unaccompanied minors who face injustices. We should be, you know, pushing for a more child-centered, children's rights-based approach to age assessments. Potentially we should be moving away from these, you know, holistic age assessments that we have. And we can see that the UK kind of departed from those core those core principles that have been established by the international framework, and they've kind of regressed from that. And I think this is kind of where the next part of my thesis will go, to kind of looking at this departing from core CRC principles. But that is my presentation. Thank you so much for listening. And I've just put some references there for you all.
Wonderful. Monique, thank you so much for that. That was awesome. Really, really, thank you so much.
Thank you so much.
And, you know, it was really nice to learn about that. You know, I lived in England for many years, and, you know, and I taught at a school where, you know, there's 54 different languages. And I know I had a couple students from Iran who were at least 22 years old, but they were identified as a child. And I didn't understand that, but now it really makes that connection.
Yeah.
Really enjoyed how you're able to lay out those UN documents and really specifically say that principle. So
Yeah.
you're really kind of bringing those in to say that there is a cause to, for lack of a better word, infiltrate those UN documents into government documents, so
Yeah.
that we treat these young people with inherent worth. I have one question. So, is there any benefit from government or the council who conducts an AA, that they identify this person as an adult when they're really a minor? Is there any benefit for the government or the council to identify as that adult in terms of services and monies, if that makes sense?
Yeah, so as I mentioned right at the beginning, it's a resource issue. Is that what is are you asking whether or not identifying a child as an adult is beneficial to the government?
Yeah.
Yeah, so again, yeah, this isn't a resource issue. This is, you know, a money saving issue. There's actually a really good paper by someone called Nando Sigona. And he almost did a cost benefit analysis of age assessments. And it was so interesting because that is kind of, you know, as sad as it is, you know, the government don't want to listen to legal people. They don't want to listen to people in sociology. They want to listen to statistics, facts, economics. And I think it was a really good exercise for Nando to kind of put that into context for them, and kind of say, well, actually, you know, here's the figures, here's the numbers. I think that was really interesting. But yeah, it's just overall, it's a resource issue.
Yep.
That's what it boils down to, and they don't want to use resources when they can just make someone wait and suffer.
Yeah, and thank you for that, because, you know, it was really nice to kind of see how you brought in this case law also, which really understood and put it into perspective, but I couldn't keep my brain from this young human being who's probably scared, sitting there and having adults who completely different culture,
Yeah.
you know, making that decision and not listening to that child,
Yeah.
you know.
And it's essentially this is, you know, the issue that we're facing, you know, every day is that, you know, someone will be sitting there as a social worker having to decide the fate of this unaccompanied child, but, you know, they might not be trained properly to deal with those specific, you know, traumas, or, you know, how, you know, even just as something as simple as language, you know, being able to communicate with that child to a good standard. I think that, like, huge issues here. So absolutely, you're so right, Matthew. Yeah, absolutely.
Yeah, no, and you know, and again, then I'll ask for some questions if they're there. I just want to make a comment that after watching that video of the school shootings and so forth, what if these people who are conducting the age assessments had to go through the medical AA just to know how indignified it can be? You know what I mean?
Yeah,
So that they can make that decision that they should do the other ones first, and
yeah,
then the AA, you know, which is nice.
yeah.
I don't know if other people have questions. I'm looking at the Q&A, but I don't see anything in there. Um, Yvonne, do you know if that's
I
up?
do.
Oh,
I
good.
would like to comment that your work is so inspirational in that you are grounding it in the Convention on the Rights of the Child and Human Rights Treaties. And you are showing us how to use that in a very pragmatic way. All right. So it is an important set of learning that you provide everyone who's attending on. These treaties are not just words on a page. This is how they impact the lives of real individuals. Right. Um, do you believe that there's a push to try to in not classify a person as a child and to put them in an adult status because that is easier and more cost effective for an institution?
Absolutely. I do think there is this, you know, underlying you know, narrative that we can't, you know, supply education and accommodation and welfare protections um to, you know, really vulnerable people. These are some of the most vulnerable people in society. And, you know, I don't know what the resource issues are like in every country. Um, but there is that, you know, that push here that we know that there is the opportunity to kind of give those resources. Um, but they just don't want to use them. And we look at the Home Office statistics, and I bang my head thinking about them every single day. The Home Office statistics, they do age assessments. They've got a whole spreadsheet of age assessments, when they've been conducted, what the outcome was, if it's been, or, you know, if there's been appeal against it, what was the outcome of that? And looking at it, around 50% of age assessment cases, first they're age assessed an adult, it then gets overturned, they're a child. So we know that this is happening. We know that this is happening. The statistics tell us that. The Home Office statistics tell us that. So I think this is an issue that I'm going to go deeper into the rest of my thesis.
Well, oh, there's a question in the box now. I tried to make my question in the Q&A and I couldn't get it in the box. So I'm glad to see that it's working now. Just one last comment that I would make is that the refugee problem is worldwide. It's not just in England. It's not just at the US-Mexico border. It is an international phenomenon, and the rules change depending on what country you were in. And the CRC holds that all children need the same criteria because they have the same rights.
Yeah.
But that is not what's happening, is it?
Yeah, it's exactly, yeah, you're so right, Yvonne. It's not what's happening at all, no.
Do you mind if I jump in? I want to say, Francis Matu is tuning in from Victoria, BC. Thank you so much for attending. It's wonderful to really have people from around the globe look at this. Monique, I had one more question, because you talked about how these children react to being poked and prodded.
Yeah.
So my question is, have you come across any studies, possibly qualitative studies or mixed method, that addresses PTSD after the fact?
Yeah, there's quite a few. So actually, I've got a friend who's doing her thesis is on the mental health of unaccompanied children. So I know there's a lot of studies out there around the mental health, trauma, PTSD, like you mentioned. Not something that I focus heavily upon in my thesis, but I know there's a lot out there because I have a friend who's actually studying that.
Oh, that's great. It'll be nice to see. So if there's no other questions or comments, I would like, oh, Greg, please, thank you.
Sorry. Monique, thank you for this. I sort of moving ahead a little bit, it's that whether it's in England or it's in Australia or America, it's that question of aging out, which is the real killer. Yeah. And you just mentioned towards the end there about the Nando's study on sort of the resources.
Yeah, it's like
how it's being a.
Sorry, carry on.
I wonder, was he looking at just the narrow issue of the cost of a childcare compared to the resources that are required as an adult, or was he looking more as sort of a longer range, examining the externalities of, all right, putting a child or putting someone who might not actually be a child, but who's developmentally not capable of functioning as an adult, sort of looking at the costs down the road of that person then being not a functional member or not able to integrate fully into society?
And I don't actually know the answer to that question because I'm not too sure what he focuses on, but it was essentially a cost benefit analysis of like keeping children in local authorities. I think that's what the study was kind of on, how much it would cost, how much finance would be needed for that. But I don't want to give the wrong information, but if you want to email me, I can email you the paper, no problem.
No, thank you. Great. And thank you for your presentation too.
Thank you everyone for listening.
Yeah, Greg, thank you so much for that valuable comments and questions. Monique, did you hear the crack of the bat? Because you knocked this one out of the park.
Thank you. Thank you so much, Matthew.
Really enjoyed listening to this and really enjoyed our call the other day to get to know you, and best of luck as you move forward. This is important work. It looks like we've got a couple minutes, well, 1 minute before the next presentation. So I'm just going to kind of push it there.
Well, thank you both for getting us started in a very wonderful way. And it's going to continue. Part of the joy of being in a network is that you get to know one another. The fellows have been working together, this group, all year. But Ralph has been a fellow for longer, and he's our next speaker. And he has been an absolute delight. He knows more people and has more resources. Every time the fellows get together, he is sharing resources and ideas, and it makes us all like kids in a candy store because we want to do it all. And we don't have the travel money, we don't necessarily have the time, but he has such an interesting world that he is so generous in sharing. And it's delightful to link him up with Bill Fernikes because he is one of the founding people of human rights education. He is the inspiration. I didn't even know about it until Bill taught me about it at a conference years ago. And so now he's on the board of Human Rights Education USA, professor at Hopkins, and has so much expertise. So being able to put the two of you together to share ideas is just absolutely joyful. So thank you. Take it away.